Hello, hello, hello. Good evening, everyone. This is Attorney Odunlami coming to you live on Instagram, Facebook, YouTube, and I am coming to you from New Jersey. How are you all doing? All right. So, I have a great topic today, and I cannot wait to get into it. Good evening, Diego. Good evening, everyone. So, we're going to talk about the Supreme Court's immigration decision. And I want to talk about it because, like I always tell you guys, knowledge is power. The more you know, the more difficult it is for people to take advantage of you as an immigrant with wrong information. So, our office is we're based in New Jersey, but we represent clients in all 50 states. We specialize in family-based petition, VAWA, U visa, T visa, SJIS, K visa, and deportation matters. So if you need assistance in these areas, please feel free to contact my office, 973-993-1900. And remember to subscribe to our channels on social media so that when we come in or come on, you are notified. Also, if you can also subscribe to my newsletter. We send out really great information. We craft these newsletters really carefully to give you the information that will be helpful to you. So guys, I am really excited to talk about this matter that the Supreme Court of the United States made. I want to talk about it. I want to talk about how it affects you, and all that good stuff. So, on June 21st, the Supreme Court issued its opinion in Department of State versus Munoz. Pardon my pronunciation. Yeah. So, this is what this case is about. Mr. Munoz, his name is Luis Asensio Cordero. He's from El Salvador, right? He's married to a U.S. citizen who is also an attorney. Her name is Sandra Munoz. So this is what happened. Mr. Asensio Cordero was living in the United States. He came in at some point. He came in with an illegal entry, which means he probably came in through the border. And at some point, he got married to Sandra Munoz, a U.S. citizen, and she filed a petition for him, an immigrant petition for him. And the I-130 was approved, which means that the relationship was a bona fide relationship. USCIS had no issues with the fact that it was a real marriage. But the problem was that Mr. Asensio Cordero came in with an illegal entry, which meant that he could not adjust his status and get a green card in the United States. So his wife filed a waiver, a 601A provisional waiver, and this is different from 601 waiver because the 601A provisional waiver allows you to request the forgiveness, and when it's approved, you can go back to your country with that approval, go through consular processing, and then you can come back to the United States. That's the way it's supposed to work, right? So he got the 601A approved because he was able to show that his U.S. citizen spouse would suffer extreme hardship if he was not allowed to stay in the United States. So the waiver was approved. So everything was going according to plan, right? So Mr. Asensio Cordero went back to El Salvador with his approved waiver and went to the embassy, the U.S. embassy, so that he could be processed and allowed to, to come back into the United States. And this is where the problem started. So, the Department of State denied his petition. They would not let him come in. And the denial was based on something very vague. I think it was based on a section that said, any alien who a consular officer knows or has reasonable ground to believe seeks to enter the United States to engage solely, principally, or incidentally in any other unlawful activity is inadmissible. So basically, the officer made a finding that Mr. Asensio Cordero was inadmissible for an unknown reason. They never told him why. So this was just certain unspecified information that they never told them. So the wife, who's a lawyer, like I told you, sued the Department of State, right? Basically saying that their finding, without telling her what the reason was, abridged her constitutional liberty interest in her husband's visa application by failing to give her a sufficient reason why Asensio Cordero was inadmissible under the unlawful activity bar. So basically, this is what happened. They said he's not admissible, but we're not going to tell you why. That's really what it was. We're not going to tell you why. So she sued them. And then the case, moved through went to the Ninth Circuit. And, at that point, I don't want to get too legal, but basically, at some point, the case came to the United States Supreme Court, right? The highest court in the land. And so, basically, the court held that a U.S. citizen spouse does not have a fundamental liberty interest in her alien spouse's admission into the United States. In a nutshell, United States citizens don't have a right to have their spouses live with them in the United States. That's what that law was, right? And so this is a thing, right? Of course, the right to marriage is a constitutional right. They didn't touch that. They're not saying that you cannot marry who you want to marry. They're not saying that you cannot marry the sex you want to marry or the race you want to marry. They're not saying that, but they're saying that you don't have a right for that person to live with you in the United States. Now, if you think about it, Miss Munoz is a lawyer. She can practice in El Salvador. So basically, what are her choices? They continue to live separately, apart, if she's going to work in the United States in her chosen profession, or she moves to El Salvador and she cannot practice as a lawyer. She will have to find something else to do. And that's exactly what the Supreme Court said. So this was a really weird, it was a really weird finding, I thought, and I wanted to discuss that with you because part of the reason that the Supreme Court, made its finding was this doctrine of consular non-reviewability. The doctrine of consular non-reviewability, which means that there's no appeal. You don't have any appeal rights to appeal the Department of State's decisions, right? You can't sue the Department of State, right, based on a decision they made. They upheld that basically the Department of State, which is the consular, the embassy, can make a decision about whether somebody can come into the United States, and that's it. It cannot be reviewed. It cannot be appealed. You can't sue them for it. So, so even when they make mistakes, you're not going to know because you don't have a right to have this information and you cannot sue them. So they can make mistakes that fundamentally affect the life of a U.S. citizen. They're allowed to make these mistakes. And that's what that decision was. So the Munoz family have they have no hope of living together as a family in the United States. And so I bring this back to the Biden parole in place, right? So for those of you that are now aware, I talked about this last week, and this is exactly what the Biden parole in place ruling is supposed to stop. This kind of, what happened. So let me break it down to you a little bit more. So assuming Mr. Mr. Asensio Cordero, and let me tell you why they found him inadmissible. They thought he belonged to a gang called MS-13, which we don't know if he did or if he didn't, right? But typically, USCIS felt this way because he had tattoos on his body that suggested that he was part of that gang. And the thing that's really crazy about it is that you cannot appeal that decision. You cannot prove them wrong. Now, Biden's parole in place basically would have removed that requirement for him to go back to El Salvador to get his visa. That's what the parole in place is supposed to do. It's supposed to allow the person who came in without admission, without inspection, without parole, who ordinarily would have to file a waiver, a provisional waiver, depart and go back to their country, go for their consular interview and come back. Biden's parole in place is supposed to, basically get rid of that. So that if you're here in the United States and you cannot adjust because of an illegal entry, as long as you qualify for I think there are 3 requirements: that you have lived continuously in the United States as of June 17, 1994, that you were married, you had a valid marriage to a U.S. citizen as of June 17, 1994, and there's one other, I don't remember the other, you have no criminal records, I think. I don't remember, there were 3 of them. But basically, if you qualify, then you can adjust your status here. Now, the issue with Mr. Cordero being suspected of being an MS-13 gang member would still come up during the adjustment of status I-485 interview and during that process. And if they find that he's inadmissible because he's a member of a gang, he still won't be allowed to get his green card. But this is a difference. He would have a process of fighting it. If he felt they were wrong, right? If he was not a part of MS-13, he could, he could fight for his right to adjust his status. And this is something he cannot do consular processing, right? So I think what is so crazy about this is the fact that a singular officer can make a determination about somebody's life, wrongfully or rightfully, and there's no legal way to fight back. Yeah. And so that's pretty much what the Supreme Court said. So I want to bring that to you guys because even Biden's parole in place, we're all waiting to see if there's going to be of course, there's going to be, there's going to be lawsuits, challenging it, and we're waiting for those, So, but if that parole in place were able to go into place, that would be really, really great because due process is really important, I don't know if the Supreme Court thought about this, carefully, but to tell somebody that they cannot live here in the United States, it's okay if you can prove that they really were inadmissible, but not to have the right to be able to fight against a finding like that. That's crazy. So I'm going to look and answer some questions, and yeah, let's see if we can answer some questions. Right. Okay. Okay. Hello. Somebody says, oops. Let's see. You know what? I cannot find the questions on Instagram. Okay, somebody says, what happened if I marry 86 days after entering into the United States with a B1, B2 visa? Tammy says, what happens if I get married within 86 days after entering into the United States with a B1, B2 visa? So Tammy, that's a really good question because I have an answer for that. So I know there's this, there used to be this presumption that if you change your status within 90 days of coming into the United States, that there's a presumption of misrepresentation, that you misrepresented your intent, right? That presumption is no longer the law per se. I mean, there's some, field offices that still, adhere to that, in the sense that they would, they'll take a look at the fact that you got married within 90 days, and, it would be up to you to, you know, basically, it's your burden to show that you did not misrepresent your intent, that you came in with intent to visit, and when you got here, you changed your mind. But there are a lot of other field offices that are not really, they don't adhere to that presumption. So honestly, I think the most important thing is, if that came up and that was a problem, you would just have to show that you didn't have that intention, and and it's really a question of fact. It's not an automatic presumption. It puts the burden on you to show that this is not the way it looks like. It's not a bright line rule. So you're not going to be automatically denied because you didn't, you got married within 90 days. Okay. I hope that answers your question. So Nilechi says, if a person's VAWA is approved April 1st, how long before they request for medical interview for the green card? Nilechi, your guess is as good as anybody's guess, because different field offices are operating on different times, depending on how busy they are. In our office, we're seeing anywhere from three months to about 6-7 months. We've had people who have been approved for a while and we're still waiting. So I would say a good rule of thumb is 3 to 7-8 months. But if it happens after that, it doesn't mean that they're not going to approve your case. It just means that they're really busy and backed up, because there's a different it's different from office to office how long the wait line is. Okay. All right. So let's go on YouTube. Hi, Michael. Hi, Mama's Love. So Michael Dow says, Michael Yao says, my B1, B2 visa was denied. Can you please help me? So Michael, it's a good thing that you mentioned this, because this case law, this Supreme Court decision I discussed actually talks about that same thing, that about the doctrine of consular non-reviewability. So what that means is that the decision of the consular officer basically is not going to be subjected to judicial scrutiny. So a B1, B2 visa is a privilege, it's not a right. And typically your B1, B2 visa will be denied if you cannot show that you have strong ties to your home country. So they think that if you're allowed to go into the United States, you're not going to come back. So a B1, B2 visa is typically denied without prejudice, which means that you can reapply again. So the important thing about when you apply for B1, B2 visa is you really want to show that you have ties to your country, which is you have your family in your country, you have a job, you have property, you have a business. And all of that doesn't mean that they're still going to grant it to you, because sometimes they just won't. But at least you want to, prepare yourself and, take the information that you need with you. They may not ask for that information. They may not even look at that information, but you don't have any control over what the consular officer decides to do. You can only control you being prepared to give this information to them if they ask you for it. Okay. So Helen says, do I need an affidavit of support for my husband and one for my son too, or can my son be on my husband's application? So Helen, it depends on your status. Are you a U.S. citizen or a green card holder? So if you're a U.S. citizen, you have to file a separate petition for your husband. You have to file a separate petition for your son, which means you have to file a separate affidavit of support for both of them. Now, if you are a green card holder and you're filing for your husband and your child is under the age of 21, your one petition for your husband allows your son who's under the age of 21 and single to be a derivative of your husband's application, and he would be included in that. Yes. So if you're a U.S. citizen, You're going to need an affidavit of support for your husband's filing. You're going to need another affidavit of support for your son's filing. Okay? All right. So let's keep going. All right. You guys, I'm not seeing any question. All right. I have one here. So, Triple A Concert says, please, if someone submitted her VAWA case for 9 months and did not receive her Social Security and work authorization yet, please, what can the person do? She only received prima facie after 5 months. Triple Concert, it's really within the, processing guidelines. What can you do? I mean, if you have a humanitarian emergency, you can file an expedited request. But if it's not a humanitarian emergency, you're going to be denied. So don't just file just to file. If you have an urgent humanitarian emergency, you can, call the USCIS website and USCIS office. Talk to somebody and tell them you'd like to expedite, and they'll give you instructions on how to fill out, how to prepare your expedited request. Okay, and that's really all you can do. All right. So let's see. Other question. All right. So Dewale says, in a sense, the ruling also affects USCIS making a bona fide marriage finding on the basis that married couples don't live together. That's not really. I'm not sure what you're saying, but Dewale, when your spouse, that's not what this filing is saying, because if you that's not what this ruling is saying. I'm not sure what you're saying, but that's not what this ruling is saying. USCIS likes for people to live together in a bona fide. They consider that proof of residency is helpful to show a bona fide marriage. But if you don't live together and you have a good explanation for that, that's totally acceptable. If your spouse is another country, you cannot live together because clearly your spouse is not able to live with you in the United States, but you would have to show other ways of proving that it's a bona fide marriage. You want to show communication between you and your spouse. You want to show that you guys, if you're visiting each other, that's really helpful. Tickets, pictures, text messages, you're sending money, that kind of stuff. There are ways of showing a bona fide marriage even when you don't live together. All right. But if you live in the same state, the same city, and you don't live together, good luck on that one. All right. So, all right. So Ikechukwu says, Your Honor, well, thank you, but I'm not a judge, says, how long do I expect my 10 years green card after, green card after passing my N400 interview? I don't know how many years should I wait before I apply for citizenship? I'm not clear on this question. If you pass your if you pass your N400 interview, you should be looking to become a U.S. citizen. All right. David Messer says, I applied for an ADIT stamp from USCIS, but I haven't heard from them. What do I do? They said they called me, but I didn't receive their call. What should I do? Because I need it for work. Call them again. With USCIS, you just need to. It's not easy reaching out to them, but just keep calling, and hopefully they will give you instructions on what you can do, because I'm not sure which field office you're working with. So you want to find out what you can do to get your ADIT stamp. Okay. Just keep calling them. So Adefila says, I'm from Lagos, Nigeria. I want to join the U.S. Army. What's the easiest way to get the green card? Adefila, there are many ways to get the green card, but I don't know your information, so I cannot tell you what the easiest way is for you. All right. So Fantiman Jojo says, may I know the duration of an I-130 for an adult son with wife and children? Well, or adult son with wife and children is taking a long time, because that's if you're a U.S. citizen filing for your adult son with wife and children, you're F3, and you have to go to the visa bulletin, because I have to check it. You have to go to the visa bulletin, check on that the F3 category, and it will tell you what cases they're working on right now. But I know it's taking a long time. If I'm not mistaken, they've been working on cases maybe 2010. I mean, I check it, but I don't hold it to memory. But I know it's taking a long time. So just go to visa bulletin for July and go down to F3, take a look and see what cases they're working on. But that's a category that takes a long time. So Light T Bola says, my family court hearing is in 1 week's time through SIJ. How many hearings would I have? So Light T, it depends on what state you are in. In some states, it's multiple hearings. Like in New York, it's multiple hearings. In New Jersey, it's just one hearing. So it depends on what state you are, you know. You might, when you go for your hearing, you can ask you can ask the judge, or you can ask your lawyer. All right. All right. So I think that's pretty much it, guys. I'll come back again and discuss other topics. Today we're going to listen to the debate, and basically we're going to listen to what President Biden and President Trump are looking to offer us if they were to win the next election. As an immigrant, I know that during the Trump administration, it was really tough for immigrants. The laws were harsh, and so yeah, the laws were really, really harsh, and they were inhumane. So as far as I'm concerned, so we're looking to see what's going on, and so all of you should be watching this, because it's good to listen and make sure you're making the right decision for you and your family, when you vote. Okay. All right, guys, it's a pleasure talking to everyone. Hey, James, how are you? All right. All right. Take care, everyone. Bye.